Hello?
All right, sorry about that, Mr. McNamee. You can hear me okay?
I can.
All right, are you expecting anyone else to appear for this?
Yes, I am. It's actually plaintiff's counsel's motion, Mr. Ifrati's motion to withdraw his counsel, so we need him here. And he is,
Okay, I didn't see whose motion to withdraw it was. I just saw it was a motion to withdraw. You know, I saw him here this morning. I don't see him here now.
I did talk to him. He said he's going to be here this afternoon, so
All right, let me put you back in the waiting room. I'll keep my eye peeled for him.
thank you.
So, Mr. Sahlstrom, oh, we're not connected yet. Mr. Sahlstrom?
Yes,
All right, and I'm looking for Dale Smith. Is that who you're expecting?
well, I wasn't certain because he consented to the motion. I know this morning he was waiting because he called me. I didn't touch base as to whether he is coming back this afternoon. He did join me.
If you, he doesn't have to be here if you can represent to me that he does not oppose the motion.
Which I do represent. I am Larry Sahlstrom here on behalf of the plaintiff, Mr. Alton, who is sitting to my right.
I'm sorry, I'll let you in too, don't I, Shannon? Just a minute.
Sure.
Shannon, I'm sorry. This is, put us on the record. This is Oughton versus Johnson.
Thank you.
And Mr. Larry Sahlstrom is present with his client, and he's represented to me that the motion for
Partial default and consent judgment is agreed to.
Is unopposed.
Correct.
That being the case, I will grant your motion. Do you have a proposed order?
There are two orders, Your Honor, and I have submitted them. One,
I see one, default and partial consent judgment. It was attached to your motion.
right. There is also an order mailed in. Mr. Smith is representing Mr. Johnson and other named clients. That there are two parcels in dispute. The main dispute was from lot 1 down to the lake. That's what we were fighting with Mr. Smith's clients about. There is a settlement signed by the clients and the attorneys, and that order has been submitted. The court made clear way back that both parcels had to be resolved to resolve all the issues, and they are now. It's just there were two orders submitted. I mean, I can submit another copy if it's not there.
Was it submitted under separate cover?
No, I submitted, well, yeah, but I thought I had submitted a copy of this order too. I mailed it.
This one I found. What I'm not finding is another order. Is it possible it's already been entered?
It's possible because I called 2 days ago, Miss Clark, and she said she thought they were signed. She wasn't certain, but I had mailed her by letter of May 3rd and she got it because that's why I called the partial consent judgment, which we all agreed to. There's, I hate doing this, but there's everyone's signature on the front page. And that's the land that from lot 1 to the water's edge. That covers my client and Mr. Smith's client. And that's a settlement, an agreed upon order.
If it hasn't been signed, I will make sure it gets signed.
Thank
I
you.
have signed I just signed the default and partial consent judgment. We'll make sure you get a copy.
Thank you, Your Honor.
You're welcome. Have a good day.
You too, Your Honor. Good. You too.
Okay, Mr. McNamee, I see Mr. Iafredi's here. We're still waiting for an audio connection with him, though. There we go. This is Smith Hughes versus Roberson. And Mr. Iafredi, this is your motion to withdraw?
Yes, Your Honor. Good afternoon.
And let me see, I want to make sure that Ms. Yvette Smith Hughes is not present. She's not signed in by that name. I do have one telephone number. I'm going to try to see who that is.
Okay.
I just let someone in with a telephone number ending in 8397. Can you tell me your name, please?
Troy Rose, sir.
Troy, say the last
Troy
name again.
Rose. R-O-S-E, please.
Rose. Okay.
Yes, sir.
Mr. Rose, I just wanted to know who it was. I've put a name with your phone number. I'm going to put you back in the waiting room, and when I'm ready for your case, I'll bring you back in.
Thank you, sir.
You're welcome.
Okay.
All right, and I don't see anything else that's unidentified or identified with either a first and last name of Yvette Smith Hughes. So it doesn't appear that your motion is opposed. Mr. McNamee, do you oppose the motion?
No, Your Honor, I just have a couple things to say though when it's appropriate time, but I do not oppose the motion.
In that case, what's your reason for withdrawing, Mr. Iafredi?
Your Honor, there's been a breakdown in the attorney-client relationship, primarily due to lack of communication between the plaintiff and her counsel. And the other reason has to do with non-compliance with requests and discovery and things of that nature. It's hard enough to practice law these days, and then when you're not able to communicate effectively with your client, it just makes it really challenging.
I will grant your motion and allow you to withdraw. We need to put in the order that Ms. Yvette Smith has 28 days in which to obtain new counsel or to request an extension in which to do so. If she hasn't obtained new counsel within that time frame, I will entertain whatever motion, Mr. McNamee, you wish to file to address what I suspect are some outstanding discovery issues, and I don't know what else.
That is correct. There's just two items, a failure to appear at a deposition and a failure to just answer a few interrogatories. On no part Mr. Iafredi's fault, but there are two discovery items that yeah, I guess I'll address after the 28 days if there's no new counsel that appears. Correct, Your Honor.
Okay, fair enough. So, Mr. Iafredi, if you could include in the order granting your motion, informing Ms. Yvette Smith Hughes of my direction with respect to obtaining substitute counsel.
Okay, Your Honor. Thank you very much.
Thank you. Your
Thank you. Sorry I had to keep you all waiting all morning.
Honor.
That's okay.
so-
It was okay.
Sorry. I'm sorry for you, and I'm even more sorry for me.
Actually, I enjoyed the motion where there was a request for a buyout of a structured settlement, and you were able to get the insurance company to pay more money. I've never seen that happen before, and that was worth the wait.
That's the first time for me. Mr. Grant has been in front of me before, so he knows I quiz people.
Right, for sure.
And this one really caught me by surprise because I saw one, I think it was like 9.4%, not all that long ago. But when he told me that they were life contingent, that it made a little more sense.
Right. It did.
But it was still nice that this lady got a better deal. So I felt good about that.
I thought she should have been jumping up and down. So anyways, that was nice.
But take care. Enjoy the
Have a
rest
good
of
day,
your
gentlemen.
Okay, thank
Yep.
you.
Bye.
Let's see. That brings us to GTSC Warehouse. Let me see who's here on this one. Looks like Jarrett Levine. Don't see that name. McKinney. Don't see that name. Shannon, did you get any kind of email on GTSC Warehouse?
Nope, not on that one I have.
All right, it was a motion to allow execution of judgment. It's possible they communicated already. I don't see any names that I can associate with this file. So we'll assume they're just going to renotice theirs. And let's see. Lakeview versus Hart. Motion for entry of default judgment. Looks like Attorney Bernardi. I see him. Good afternoon, Mr. Bernardi. Are you expecting anyone else?
I am not, Judge. Sorry.
This is Lakeview Loan Servicing LLC versus John Hart. I don't see any party names in the waiting room, not surprisingly. No opposition to your motion was filed. And are you asking for entry of a default judgment?
Yes, entry of a default judgment, quieting title to the property to correct the scrivener's error in the mortgage. So there's no monetary award. We're just seeking to affirm the validity of the mortgage with the proper legal description.
Well, no opposition was filed. I'm not surprised. And no one has appeared today to oppose. Did you submit a proposed judgment
I did, Your
with your
Honor.
motion?
Sorry, Judge.
Let me
I
see if I can
did.
find it.
It's attached as Exhibit H.
Oh, okay. I see Exhibit H. Let's pull that out. Yes. Let me separate that. I will sign it and we'll see that gets sent back to you.
Okay, so just to clarify, in this crazy world of Zoom, you don't want me to submit more copies of the judgment? You will just sign that and we'll receive it by mail?
Yes.
Okay, perfect.
I've signed your judgment, and we'll see that a copy gets sent to you. Thank you, Mr. Bernardi. Sorry to
Thank
keep you
you.
waiting.
Thank you. Have a good weekend.
You too. And let's see, Rose versus Powell. Uh,
Hello, Your Honor.
Good afternoon. How are you?
I'm great. I'm great. This is Brian Zaid on behalf of some of the roses. Oh, most of the roses.
Oh, there's a bunch of roses. Okay, I should let them all in, hey?
Yes. Cassandra Rose is the personal representative, and she's joining now, it looks like. The phone call that you had earlier was Troy Rose, the brother of the deceased, who is the one person who did not approve of the distribution recommendation. Your Honor, this is plaintiff's motion to approve a wrongful death settlement. And Mr. Cobb.
Hold on a minute. I want to make sure I got everybody in.
Sure.
It looks like, let's see, I've got Adam Rose, Troy Rose, and I'm waiting for a connection with Cassandra Rose.
Yeah, it says connecting to audio on my end.
Yeah, I've got an image, so it's slowly coming into view. Sometimes, and I don't know if it's because of a device or because of slow internet, sometimes it takes a while to establish a connection.
Right. I know she's been with us all day, and earlier when it was grouped, she was there, so she should be with us momentarily, and I really hope that she gets in quickly before we get bumped, because I do have to be done here by 3. I have to take off for something, so I hope she shows up soon.
Does this something involve a little white ball?
No, I wish. I would love to be golfing today. I have to go out to Redford and pay a re-inspection fee for a certificate of occupancy. So no, not the plan. Here we go.
Well, she's visible, but I still don't have an audio connection.
Okay, Cassie.
If you have a, oh, wait a minute. Let's see. No. Thought we were there.
Close.
If you have a telephone number for her, I can try calling the telephone number, and that will. Oh wait, we got it. Ms. Rose, can you hear me?
Yes.
Awesome.
Yes, I can hear you, sir.
Beautiful. Okay.
All right. So let me just verify. This is the matter of Rose versus Powell. Mr. Zaid for the plaintiff, Mr. Cobb for the defendant. And we've got several interested parties present: Adam Rose, Troy Rose, and Cassandra Rose. Mr. Adam Rose, can you hear me?
Yes.
Mr. Adam Rose, can you hear me now?
Yeah, I can hear you.
All right, Mr. Troy Rose, you can hear me?
Yes, sir.
All right, go ahead, Mr. Zaid.
Okay, thank you, Judge. This is plaintiff's motion to approve a settlement for a wrongful death claim that was brought on behalf of the estate through the personal representative, Cassandra Rose, who's with us today. Your Honor, I represent the entire estate for the most part. First time in a long time. This motion is actually being disputed by one of the estate members. His name is Troy Rose, and he is with us today via telephone. Before we go through with the request for the approval, I would like to give some guidance, some background, state a position. And what I'd like to do, Your Honor, to make things a little bit easier for all of us, is state what our intentions are, why, and the legal background for it. At that time, Judge, if you are so inclined to approve our request for distribution without having to get into some of the familial mudslinging that may occur, I would allow an opportunity to respond if that does occur. Now, if it's approved without having to get into that, we can immediately get into the voir dire for the distribution and the request for approval. I state it that way, Judge, because the reason that we have Mr. Adam Rose, that you can see visibly, and other family members that don't have video but are here, is because it's the children. The children of the deceased are here and they request the distribution, as I stated in my motion. And so that's what we're hoping to make it easier on the family and easier in process. So with that, Your Honor, I'll begin with what we request, why we request it, and then I'll wait for an opportunity to respond as to why we think you should do it that way. Is that fair? Can we do it that way, Judge?
Well, whether or not I can approve it that way, I guess depends on what I have to hear.
Exactly. Okay, so here's where we are. Your Honor, my client, and the reason I'm asking this first is because normally I'll just go through the voir dire. So before we start that with Ms. Rose, I'll point out a few basic facts and then the scenario. My client was killed in a motor vehicle accident, and Mr. Rose was survived by 4 children. He also lived with his 2 sons. The 4 children have agreed to amicably divide the funds up equally amongst the 4 of them. Mr. Rose is not just survived by 4 children, but he also has a brother. Well, he's got 1, 2, 3, 4, 5, 6 siblings, all of which, except one, agree to the distribution, which is to give the money to his kids, which is the noble thing to do, which is what the most common thing is to do. And the reason we request that no mudslinging do occur is, Judge, I'd like to point out to 2 factors. Number 1, I would like to point out for this court that Mr. Troy Rose did contact me, the plaintiff personal representative lawyer, to indicate that he does not approve of the distribution and he would like some of the funds. So whether or not that properly satisfies the requirement of subsection 8 of the wrongful death statute is not my concern at this point. He did contact me and that's why we're here today. However, with that, Your Honor, I still don't think it satisfies. He needs to be able to prove and show material fact that he has a right to the proceeds. By doing so, there's 2 cases that we point to specifically. Carr, 189 Mishap 234, measure of damages is gauged by the relationship the decedent had with the claimant and the amount of time the decedent and claimant spent together. That's McTaggart versus Lindsay, 202 Mishap 612. Judge, knowing those 2 factors, also using the guidance given to us by the intestate succession laws in Michigan, which I think are not exactly specifically pertinent, but can give us great guidance, that when there is no will and someone passes, the first in priority is children. Children inherit everything, and that's what we're asking for. This is not a recommendation for you to approve based on the fact that there are other siblings. We're not giving anything to any siblings. We're not recommending that. In fact, all the other siblings would like for you to order all of these funds to be given directly to the children. There's 4 of them. No one deserves it more than Mr. Brian Rose's children. The relationship he had with them was paramount. He spent all of his time working or caring for his children, spending time with his grandchildren, and living with his sons. To do anything otherwise would be upsetting, to say the least. So that being said, Mr. Troy Rose calls and indicates to me that they had a strong relationship and would like to have portions of it. So at this time, Judge, before I do get into some of the pertinent facts that the family has given to me that I'd like to produce for you, I would like to ask that that gets approved. If you want to speak to Troy first, I reserve an opportunity to respond at that time before we can make things worse for the family. If that's necessary, I'll be happy to do so. I also have the family here so that they may respond. If you care to ask the personal representative or anyone else questions, you can do so, Judge.
So, Mr. Troy Rose, you can hear me?
Yes, sir.
So, I think Mr. Zaid has set forth what the wrongful death statute would require. Certainly anyone who's identified in the wrongful death statute as a potential, I don't know if it's called a beneficiary under the statute, or someone who is entitled at least to come forward. First of all, required to receive notice of the settlement of the claim. And then my understanding is then I have to take testimony and determine the relative strength of the relationship between each claimant and the deceased. And then I'm called upon to make a decision as to how it should be distributed.
Excuse me.
Typically what happens is people agree on this. I think what Mr. Zaid has said with respect to what usually happens here is often when there's a surviving spouse, that surviving spouse very often will get the entire award. If there's a surviving spouse and children, sometimes there's some allocation. It's far more unusual that siblings, in the case of someone who has a surviving spouse and surviving children, participate in such an award. But ultimately, what I'd be required to do is evaluate the relative strength of the relationship that exists between each potential claimant and the deceased. So how close were you with your brother?
Okay. Are you ready for me, sir? Yes, sir.
I'm not. What I'm not going to do today is an evidentiary hearing and hear from everybody and hear family mudslinging. That might be reserved for another day. But I at least want to hear what you have to say, and perhaps I can give some guidance short of conducting an evidentiary hearing. So I'm just asking you, if I were to have an evidentiary hearing, what would you tell me as to the strength of your relationship with your brother?
Okay, sir. I grew up with him. We were friends my whole life. I mean, he was my best friend. I worked with him for 26 years at 2 different places. 18 years with my dad, and about 6 or 7 apartment maintenance. We were real close. He was my best man at my wedding. I talked to him every day, if not every other day. He was the guy I looked up to. I mean, my dad, we worked with my dad for 18 years together. And my dad was always saying he was going to give us some business, and he did. So in 2019, my brother had to get a job at a shop. We were slow. He has a family. So he did do that. And I just, Peyton, we were good. Like I said, we were close. We did things. I mean, sure, we had disputes and stuff, but he would do anything for me, and I would do anything for him. Just like his kids. I love his kids. And this is probably going to tear, the kids probably going to hate me for this. Sir, he was my best man. I mean, like my dad. I got 3 best, true friends, sir. It was my father, my brother, and another guy, John Talley. But I worked with my brother my whole life, sir.
All right, I can accept what you've said as an offer of proof. So, Mr. Zaid, if I were to go forward at some future date with taking testimony, what would your offer of proof be?
Your Honor, I think you can see. Hold on, Troy. This is my turn. Judge, as you can see,
I'm sorry.
What you can see physically from my clients, specifically Cassandra and Adam, the pain that he's putting them through is almost worse than what they've already gone through. They're both emotional. They're listening to a person say things that are just blatantly false. I'll tell you a few things, and here's what the offers of proof will be. Number one, Mr. Troy Rose has a conviction history of cocaine. He was incarcerated for 1.5 years within the last 3 years, so his time spent with Mr. Brian Rose couldn't have been that close. It's not the first time offense. He's had drug-seeking behavior as far back as 2007. He's also got larceny charges that are convictions on his record. Part of those larceny charges also are related to the fact that he has stolen tools and things from their father. The businesses that they had together, clients were stolen from. This has been a long long-standing family problem and history of theft, of drug seeking, and simply not what he's talking about. And as you stated yourself, Your Honor, we got a family.
Mr. Let me stop you for a minute. So, Mr. Zaid, if I were to hear testimony, will I hear testimony that because of the issues related to the business, that Mr. Rose, Mr. Troy Rose, and Mr. Brian Rose were not on friendly terms at the time of Mr. Rose's
Yes, Judge.
untimely death?
In fact, what you'll hear specifically from Missy Mosley, oldest daughter, up until about 2.5 to 3 years ago, Troy and Mr. Brian Rose, deceased, worked for their father together until father got sick and passed away. And at that time, Troy stole clients' tools and ran the business into the ground. Brian was no longer associated with that business that was starting created by their father. Brian worked constantly. He got a new job at a different company, working very hard to build and support his family. Troy and Brian Rose, deceased, also fought constantly because Troy would steal tools from Brian. These are things that the family, the children, are going to testify to, as well as the siblings, if necessary.
Okay.
Stop.
Let me stop you then. So, Mr. Troy Rose, today I'm not taking testimony. I'm not in a position to evaluate your claim that you were real close with your brother, or Mr. Zaid's offer of proof that there will be others in the family testifying that the relationship was very strained. If I conclude that the relationship was strained, as Mr. Zaid describes, I can tell you I would not be awarding you any portion of this wrongful death settlement. If you still want to put the children and your siblings through an evidentiary hearing, that is your right. But if that's what I find to be the case, I would not be awarding you anything. Do you understand that?
Yes, sir.
And you still want to put your nieces and nephews through this kind of a hearing?
Yes, sir, because I just worked with him last year. He helped me on a side job, one job, and it was in the springtime, between spring and summer, over at Clark Lake. We did outside house. My brother had loaned me $500 within about 2 months period, sir. He passed. I owed $500. We had such a strange relationship.
I don't want to hear anymore. I don't want to hear anymore today.
I'm sorry, sir. Okay.
I've heard enough to tell me I can't decide this without taking testimony.
I understand, sir. Yes, sir.
We'll have to find a time to do that. I think I can approve the settlement, which would, I think, get Mr. Cobb out of the picture, if I'm correct. But I'm not in a position to approve the distribution until I can take some testimony.
Your Honor, can I just point out that if we go through with this, it's going to cause a lot more problems for the family. And if any funds are actually given to Mr. Rose, they're simply going to go into the underground drug world. He has shown no indications of him being recovered from any of the cocaine addictions that he's had. And the family can testify to that as well. All he's doing is making this harder on the siblings and the children. And it's just not fair. We shouldn't have to be put through this. We should, I respectfully request that we reevaluated, Your Honor, before we close the hearing today.
I've got to take testimony to decide this. We've got disputed facts, Mr. Zaid. There's no way I can do this without taking testimony.
Okay. So do you want me to
again, I can.
I'm sorry.
I can approve the settlement, though, if you establish some factual basis from Ms. Rose.
Okay. Then, Judge, if I may, for the rest of the family, specifically Troy, Adam, Melissa Mosley, whoever else is present, they don't need to be here for this. If they want to leave, they can. If they want to stick around, they may.
Okay. Ms. Rose, would you raise your right hand, please?
What's that, sir? I'm sorry, I couldn't hear you.
I'm talking to Ms. Rose. You can listen, but I'm done with you for today, Mr. Rose.
Okay, thank you, sir.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You could put your hand down now. Please state your full name, please.
My name is Cassandra Marie Rose.
Go ahead, Mr. Zaid.
Cassandra, are you okay?
Yeah.
Okay. What I'm about to do is ask questions now specifically related to just the accident and the settlement and nothing about the distribution. Obviously, you heard the judge's ruling and we'll have to come back at another time, okay?
Okay.
Do you understand that?
Yeah.
Okay. Now, in terms of what we're going to proceed with today, this is going to allow us to have the approval for the settlement, and then Mr. Cobb is here with us because he represents the insurance company. After today, he'll be gone and we'll continue as the judge indicated. You ready to go?
Okay.
All right. You understand, Cassandra, that we're here today because of an automobile accident on September 10th, 2020 that unfortunately took your father's life.
Yes.
And you understand as part of that accident, you hired and retained the San Bernstein law firm to represent your family's interests.
Yes.
And as a result of that representation, we were able to come to a resolution with the insurance company on behalf of the driver of the vehicle.
Yes.
And you understand that the resolution that we came to with that insurance company was for the full amount of the purported policy limits of $250,000.
Yes.
You understand that by coming to a resolution for the full policy limits, that there is no other funds that are available to the estate by way of insurance company policy, right?
Right. Yep.
That doesn't mean that your father's life is worth $250,000. It's simply the most amount that you would be able to get from the reported insurance policy limits.
Right.
You understand that as personal representative, you have been appointed to be in charge of this decision, correct?
Yeah, correct.
And by being in charge doesn't mean you're a rogue and make decisions on your own. You take the best interests of the estate, which would include your siblings, right?
Of course. Yes.
And also the other interested members of the estate, right?
Right.
And as a result, collectively, the estate decided through you that it would be in the estate's best interest to resolve this claim for the policy limits of $250,000.
Yes.
Now, you understand that if you do not decide to resolve this claim, you have a right. The estate has a right to go to trial and get your day in court before a jury of your peers.
Yes.
And you guys are giving up the right to do so for purposes of what you think is in the best interest of the estate, which is a resolution of policy limits.
Yes.
Okay. Now, and at this time, we're going to ask the judge to approve the settlement. But before we get there, I want to break down a couple of numbers, even though they're not final until the next hearing. I want it to be clear that you understand that out of the $250,000, there are costs and attorney fees that are to be deducted first.
Right. Yep.
And after the deduction of the cost and the attorney fees, the net amount that will be distributed to the estate after a decision, when we have a hearing, will be $160,100.35.
Yes.
Okay. You understand that after the hearing and a distribution is ordered, if in fact our recommendation is approved, it would be an equal division 4 ways amongst you, Cassandra Rose, your sister Melissa Mosley, and your 2 brothers, Brian Rose and Adam Rose.
Yes.
Thank you. At this time, Cassandra, one last question. You understand that by asking the judge to approve this, that this is a full and final resolution of all claims against the at-fault driver and the insurance company on his behalf, and you can no longer in the future come back and ask for any more funds?
Yes, we do.
Okay, thank you, Judge. At this time, I have nothing further, and we, as plaintiffs, ask that you approve this settlement in the very least.
Well, let me ask, because I was of the impression that this was a wrongful death settlement, which the claimants in are the survivors. Was there no conscious pain and suffering that was made on behalf of the estate itself?
Your Honor, there was no conscious pain and suffering claim made as a result because it was determined that Mr. Rose was rendered deceased at the scene with no conscious pain and suffering. It is
Thank you.
wrong.
Mr. Cobb? Mr. Cobb, did you have any questions for Ms. Rose?
I do not have any questions, Your Honor. Thank you.
I'm satisfied based upon the testimony that this settlement is indeed in the best interest of the persons entitled to participate in a wrongful death settlement. And I'm going to approve the settlement amount. We'll have to wait another day for me to take some testimony and determine what the distribution of this settlement will be. I'm assuming you're prepared to move forward with that pretty quickly, Mr. Zaid?
We can do it right now if you want, Your Honor.
I wish I could, but
I know
I still got several people in the waiting room, so it's just not practical to do it today.
Certainly. I know you can't, and I certainly understand that. I just want you to know that they are ready because we're prepared, and I have screenshots. I'll skip my appointment I told you about. We can do this at 4 o'clock if you want, because I've got PDFs up and ready to go for screenshots to show you the proof of what I told you about the convictions.
I'm going to lose my staff here very shortly. I'm just not going to be able to do it today. I'm sorry.
Sure,
So
no.
what I will do, I'll have someone get a hold of you to arrange a date just as soon as possible, and we'll get this resolved as quickly as we can.
Thank you, Your Honor.
Thank you.
Thank you. Thank you.
Thank you.
Cadoo is off. That's the next one.
Ever hear that John Anderson song? It's "I'm the black sheep of the family." I think this might be the guy. It's actually a pretty funny song.
I've heard the term before, but
You're not a country music fan, I take it?
I am.
So you know who John Anderson is?
I've heard of him.
He's the one that sang about Charlotte, the guy swinging with Charlotte on the front porch.
I'll have to give him a listen this afternoon.
It's a classic. I like him, actually. He's got a very distinctive style. Okay. Rose. Oh, I read a note for this one. Maybe we should cue that up and play it while this guy's testifying at the hearing. Hilltop versus auto owners. What do we got? Roll, Bonham, Griffin, Girardet. No, I don't see anybody here on that one.
Which one? Hilltop?
Yeah. And I'm out of files. What else we got? We got a status conference. Let's see if anybody's here on that. Reynolds and Hyde. Nope. Great Lakes we did already. Here we go. Looks like some pre-trials. Okay, I see Mike McFallahee. And let's see, Dennis.
I assume you do not want these on the record, Your Honor.
Yes, you can take us off the record.